Welcome to Shaping Canada, 150 Years of Landmark Decisions. The Canada we know today wasn't built by chance. Argument by argument, judgment by judgment, it was forged by law within a unique justice system born from the union of the civil law and common law and increasingly Indigenous legal traditions. In this series, we mark the Supreme Court of Canada's 150th anniversary by decoding some rulings that defined our rights, our freedoms, and our collective identity. From criminal law to Indigenous rights and the division of powers, the decisions we chose to share with you are not just ancient history, they still shape our reality today. I am your host, Hugo Martin, and I ask you to join me for exclusive conversations with the 9 justices of the Supreme Court and leading constitutional experts as we uncover the context, the impact, and the lasting legacy of these judgments.
The Canadian Charter of Rights and Freedoms guarantees our freedom of expression, our freedom of religion, and the presumption of innocence. But are those rights absolute? To help us unpack this question, we are joined by Professors Marcus Moore and Joel Bakan. Marcus Moore is an assistant professor at the Peter A. Allard School of Law at UBC and a former law clerk to Chief Justice Beverly McLachlin. Joel Bakan is a professor at the same institution, the renowned author of The Corporation, and strikingly was a law clerk at the Supreme Court of Canada during the time of the Oakes decision. Together, we dive into the landmark decision of R.V. Oakes, a ruling that fundamentally shaped how we understand the limits of our charter rights. David Oakes was caught carrying an illegal drug. Under the Narcotic Control Act at the time, simply possessing it triggered a presumption of trafficking, effectively forcing Oakes to prove his innocence, a reverse burden of proof. The question before the court was fundamental. Can the government override the presumption of innocence in the name of fighting drug trafficking? The court's answer created the Oakes test, a legal framework that has guided almost every charter case since. So in the end, did the law make it through the test? I am Laurence Laperrière. Listen and enjoy this episode to find out.
Well, thank you both for being here. Professor Bakan, you served as a law clerk for Chief Justice Brian Dickson during the time of our landmark decision that we're going to talk about today. For those who may not be familiar with what is a law clerk at the Supreme Court, can you tell us what exactly a law clerk does and how was that experience for you?
I have to say it was probably the greatest experience of my legal career so far. I was a law clerk to Chief Justice Dickson, and so being a law clerk to the Chief Justice is really interesting because you're not only dealing with the substantive law, but you're dealing with the sort of leadership of the court, which is really quite fascinating. The job of a law clerk is mainly to do research and writing for the judge. You read through the factums, you write what are called bench memos, which basically give the judge a quick overview of the argument and, that prepares them to sit on the bench and hear the case. Then often the judge will ask you to write a judgment memo, all that kind of stuff that's useful to the judge in writing a judgment. And another sort of major role of the clerk is reviewing leave to appeal applications. So the court gets many leave to appeal applications, rejects most of them. The standard, of course, is that a case has to be of national importance and national concern. It's not about whether the lower court was in error. And so you apply that criteria and you write a short memo for your judge, sort of explaining what you think about how that criteria is met or not met in a particular submission.
Professor Moore, can you tell us about your experience at the court?
Yeah, I think a lot of it was very similar to what Joel described. You're doing research for the judge to assist them in preparing for the case. You're called into meetings to brief the judge on the background and answer questions they have. If your judge is going to be writing an opinion, you're going to put something together in writing to get them started and help them revise drafts. If there's memos coming from other chambers of other justices, then you'll be brought in to advise the judge about what's behind this memo and how to respond to it, and just working with the case while it's under reserve until a final judgment is released.
Let's slowly introduce our landmark decision. Professor Bakan, early 1980s, so the charter was not adopted yet. Tell us, what was the lay of the land? What was the feeling in the air regarding the soon approaching of the charter?
There was a feeling probably starting to germinate at the close of World War II or during World War II that protection of human rights was a very important endeavor of nation states and of international institutions. The United Nations formulated its Declaration of Human Rights. There were various covenants that came out of that. Nation states, including Canada, were signing those covenants on civil and political rights, on social and economic rights. There was this increasing concern that Canada should have a constitutional Bill of Rights or Charter of Rights. And by 1982, of course, that happened. 1981, prior to that happening, David Edwin Oakes was sitting in his car, parked near a tavern in London, Ontario, when Constable Hatfield of the London Police Department tapped on his window and demanded to search him. And the constable found vials of cannabis resin, hash oil, several $100s in cash. And Oakes said, look, those files were for my own use. But instead of being charged with possession, he was charged with possession for the purpose of trafficking under the Narcotics Control Act. And that made him liable to life imprisonment. So I don't think in that moment in 1981 he could have imagined that his case would end up becoming a seminal and definitive leading case in Canadian constitutional law, but that is what happened.
Professor Moore, before 1982, the Bill of Rights was insufficient?
Yeah, so the problem with the Bill of Rights versus the Charter is that it's just ordinary legislation. And so it can conflict with other legislation, can be repealed, it can be overridden. The benefit of constitutionalizing the protection of human rights is that the Constitution trumps ordinary legislation. So it's beyond the reach of future governments or provincial governments to interfere and infringe on the human rights once they've been granted that constitutional protection. So that's really the impetus for why Pierre Trudeau and his government wanted to entrench those rights into the Constitution itself. And that's also the case, internationally, right? We see similar rights in other countries that are part of their constitutions, so they have that status.
The Section 1 of the Canadian Charter is fairly simple. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society.
Section 1 is a very interesting provision. It was part of the compromise in that a lot of people were concerned with the charter that it would give too much power to judges, that it would enable them to dictate policy in ways that countered the way that policy should be formed in a democracy. So there was a real concern about sort of judicial authority overriding democratic governance. And that concern was particularly sharp in Quebec, where the government of René Lévesque, the Parti Québécois government, didn't sign on to the charter because it really was seen as a federal instrument with a federal court that could unduly dictate law and policy in the province of Quebec. And I think that concern remains a concern and has remained a concern and has been a large part of our constitutional politics since 1982. Prior to the Oakes case coming up to the court had decided a number of big charter cases. And in those cases, there were really no criteria for determining whether a limit was reasonable and demonstrably justified in a free and democratic society. The court kind of went on it on a hunch, like, well, yeah, it seems reasonable or it seems demonstrably justified, or it doesn't. But there were no criteria. And this, I think, was becoming frustrating for Chief Justice Dickson, this prospect, this kind of ad hoc approach to this very important question of whether a law that restricted a right should nonetheless be maintained and shouldn't be struck down because it was reasonable and demonstrably justified. Here was a case that pitted an ancient and hallowed individual right, the presumption of innocence, against a powerful collective interest, which was stopping illicit drug trafficking. And I think he saw in this very sort of clear clashing of values an opportunity to create principles for applying the section. And so the Oakes test, as it quickly came to be known, was a result. And it basically says that a law that limits a charter right can be upheld under Section 1, can meet the standard of being reasonable and demonstrably justified if its purpose is pressing and substantial, if its means are proportionate to its ends, and if its positive effects are weightier than its negative effects. That was kind of the ladder of analyses that the Oakes test created.
Does it have more emphasis, the fact that it's Section 1?
Section 1 does a couple things. It's also the same provision that guarantees the rights. So it comes first, and it guarantees the rights that follow, subject to the limitation that's found in the remainder of the clause, about having to be a reasonable limit that's demonstrably justified and so on. So I think that's the reason for why it comes first. And there are different ways of addressing the scope of human rights relative to, the freedom of maneuver of government to address collective interests. In the United States, they tend to use an approach of taking each right and defining the limitations internally to each right. Whereas in Europe and internationally, there are limitation provisions similar to Section 1 of the Canadian Charter that apply to a number of rights or all of the rights. And so that's sort of going to the structure of the Charter and how Section 1 relates to the other rights that are enumerated. It just makes sense to have it there at the outset, both guaranteeing the rights and explaining their scope.
Prior to Oakes, how were the constitutional experts reading it? Were they saying that, it's too broad in scope, or we will never get the right interpretation from this?
There's a long history of conflict among constitutional scholars about how to deal with limiting rights. And that conflict was read into the Section 1 debate that scholars were having prior to the Oakes decision in 1986. And the basic conflict is between an approach that is often described as a balancing approach. And so the balancing approach says that the job of judges is to balance the competing interests at stake. So balance the interests that are protected by the right against the collective interests of society, and in a judicious and reasoned and principled way, try to figure out which is the more weighty of the two and make your decision on that basis. And so the word reasonable and demonstrably justified can lend itself to that idea that this is really about a balancing of competing interests. And so that was one idea that you saw in scholarship. The other idea, rather than sort of trusting judges to strike the right balance, was an idea that said, well, what we really need are rules and principles that bind judges to reach the right result. So we need a set of criteria that ensure that they end up with what is reasonable, what is demonstrably justified, and whether legislation should be maintained. The Oakes test basically incorporates both of those approaches. On the one hand, it has a fairly metricized kind of approach in asking whether there's a good fit between the means of the legislation and the ends, the purpose that it is seeking to serve. Are the means rationally connected to the ends? Are they the least restrictive of a right possible? Is there that good fit? But then the third level of the test sort of opens up a balancing kind of approach, namely, how do the positive effects of the legislation weigh up against the negative impact it has on rights? So that's kind of an open balancing. The test really draws on both of those, and both of those approaches, in turn, you can look back all the way to the jurisprudential scholar Hans Kelsen in the early 20th century, and see European jurists talking about proportionality as the way to understand rights. Again, there were debates. Does proportionality mean balancing the good against the bad, or does it mean measuring the fit of means to ends? And you had all those debates. And, I guess the good news is that with Oakes, we've got it all. All of those approaches are built into the Oakes test.
So we have a simple drug possession case that arise from prior the adoption of the charter, but what were the legal issues before the Supreme Court?
Well, I already mentioned that Oakes found himself liable to life imprisonment because he was charged with possession. But even worse for him is that there was a reverse onus clause in the act, meaning that he was automatically presumed guilty of trafficking by virtue of the fact that he had drugs in his possession. And therefore, he had to prove his innocence in order to avoid being convicted of trafficking and serving a lifetime in prison. And so that reverse onus clause was really what sort of got this case up to the Supreme Court. I mean, the court pointed out that with this reverse onus clause, if Oakes were able to adduce sufficient evidence to raise a reasonable doubt about his innocence, but didn't convince the jury on a balanced probabilities that the presumed fact that he was trafficking was untrue, then he would be convicted. So he'd be convicted despite the existence of a reasonable doubt about his guilt. And it was on that basis that the court said this violates the presumption of innocence.
So that's Section 11D.
That's Section 11D, a hallowed principle lying at the very heart of criminal law that is necessary in a society committed to fairness and social justice. We're in the early 1980s, and I remember this well. There was a war on drugs. This was Ronald Reagan and Brian Mulroney and Margaret Thatcher. There was this sort of turn to a more conservative kind of politics and a broad public opinion favoring tough anti-drug measures. And so there was a strong collective interest here in eradicating drug trafficking. And the reverse onus clause was seen as a way to really assist in doing that. You would just, anybody who happened to have some drugs in their possession would have to prove that they weren't traffickers. And you were going to catch a lot more traffickers this way. You were widening your nets. The problem is you were also going to catch more non-traffickers. And that's where the problem came up for Section 1. So what the court said is, when we look at the Oakes criteria, is there a pressing and substantial purpose to this law? Yes, there is. It's trying to eradicate the ills and the evil of drug trafficking. But the court said the means were not rationally connected to the ends. The legislation, Section 8 of the Narcotics Control Act, failed at the first proportionality test. And the reason they weren't rationally connected is because you would be catching a lot of people who were not drug traffickers, and catching people who aren't drug traffickers doesn't serve the purpose of catching drug traffickers. And hence, there was no rational connection. That's how the court reasoned it out, and that's why they reached the decision they did, and with a lot of controversy in doing so, especially in this time of the war on drugs. The court struck the law out at the stage of rational connection. They found no rational connection, so they didn't go further.
It's still a four-part test, but it rarely goes all the way down to the fourth question, which is a proportionality between the deleterious and salutary effects of the law. Professor Moore, what are the impacts of Oakes? How did it evolve throughout the years?
Well, it's obviously become a very famous test, that's the linchpin for deciding these conflicts between individual human rights and these important pressing collective interests. And so whenever we have that type of situation come before the courts, then they're going to have to use this Oakes test that they developed and that at this point has been around for a long time and is tried and tested and not only in Canada, but has been something that has been looked to as a model around the world. It's very well known. It's very prominent and for good reason. It has these different steps that Joel mentioned. Checking, first of all, from an instrumental point of view, that there's a rational connection to the measure the government's wanting to use. in terms of its objective and what it's actually proposing to do. And then, making sure it doesn't go too far, which, Jewel was saying that probably Oakes should have been decided on that basis, that it was just going too far, not that there was no connection whatsoever. And I think the subsequent jurisprudence of the court would agree with him on that in terms of, understanding better the different steps. And that final step that traditionally the court hasn't gone to, balancing the overall effects. So, there has been in the last 10 years, there's a case in 2016, KRJ, where the court said that we should shift, more emphasis towards that final step and take some of the emphasis off that minimal impairment test, which is about assessing whether the right has been limited as little as possible in pursuing the objective, and put more emphasis on, the weighing of the overall effects. So we see some shift in that direction, but it's not consistent. So in any given case, on any given day, it may well be that the courts are still going to rely predominantly on minimal impairment.
The Oakes test, is it too strict? The same year that Oakes was rendered, the Supreme Court applied the Oakes test on a much more flexible way in Edwards' books. Were they sending a signal right away?
Edwards' books is interesting because in it, Justice Laforet basically says, I'm not going to follow the Oakes test. He said, forget about all those tests. We're just going to balance the competing interests. And he ends up proceeding in that way. I don't think that balancing tests are necessarily any more or less strict than principle-oriented tests. The whole question is really how the court goes about doing what they're doing. And that is going to depend a lot on values. And there can be real differences in values. One of the really interesting comparisons is the Keegstra case, a case about hate speech. And when you look at the Keegstra case, there are two incredibly persuasive, elegantly reasoned judgments going in totally contradictory directions. One from the Chief Justice, which turns out to be the majority opinion, and one from Justice McLaughlin, who's in dissent. And whether you were adopting a balancing approach like Justice Laforet adopted in Edwards' books, or the Oakes kind of rigorous approach, I don't think makes as much a difference as the fact that those two judges in Keegstra had very different presumptions about what and how freedom of expression might be threatened, about where it's appropriate for the criminal law to step in to protect minorities from hate speech, about the potential of slippery slopes once the criminal law starts doing that. Where will it stop? I think the real issue is one of values, and I think the virtue of the Oakes test is it kind of forces those values into the open. One of the problems with balancing tests is there's always a previous decision before the balance is done about what is being balanced against what. And in making the decision about how to characterize the interests, usually the entire thing is done. That one interest will be characterized in a way that makes it seem very weighty, and the other in a way that doesn't. And so the process is kind of hidden there. The values are kind of hidden. The advantage of the Oakes test is you really have to run this gauntlet of these principled and rational kinds of tests that really force you to engage in a very reasoned kind of approach. Marcus was talking about the fact that the fourth leg in the Oakes test typically isn't reached. Well, it isn't reached in cases that strike down legislation because that usually ends at minimal impairment. But it is reached in every case that upholds legislation. Because in order to uphold legislation, you have to meet all four tests.
Critics argue that the structure of the Oakes test forces courts into a mechanical analysis, potentially obscuring the ultimate question of whether a rights infringement is truly justified in a free and democratic society. Does the Supreme Court have the pulse of the society in order to determine if a right infringement is truly justified in a free and democratic society?
Well, there's different ways of courts handling conflicts of values. They can use what's called formalistic reasoning, which the Oakes test is partly an example of that, and as opposed to policy reasoning where they just say, oh, this value outweighs this other value in our opinion. So the Oakes test goes through this sequence of steps in a certain order, and it looks like a mechanistic, process. If you look at the wording of the different steps, we're measuring things. It's like a scientific exercise that tends to de-emphasize the subjective evaluation that the judges are engaged in. It can be criticized as being less transparent. On the other hand, it does protect the judiciary in having to make these kinds of decisions, which they have to make, and makes it look like an exercise in interpreting and applying the law rather than just, people in robes making political decisions. It's not uncommon for the law to use that type of reasoning. But I would say that it's not entirely formalistic reasoning, right? That fourth step that involves the kind of open acknowledgement and weighing of the different values that are at stake is the one where you can sort of, in a more upfront manner, engage with them, acknowledge them, give expression to them, and ultimately they have to be weighed.
You mentioned earlier that the Oakes framework was used in other countries. What makes it so exportable, according to you?
Well, I mean, the proportionality model, which, the Oakes test is an example of, is something that's been around for a long time. It also started in a criminal context, in particular with relation to the use of police force in Germany and whether it was a case of excessive use of force. So that's where proportionality tests originated, and then they've sort of proliferated from there. They became more widely used in the German Constitution and then in the European Court of Human Rights. And then the Oakes test is another model that has been appealing to many countries around the world.
Should we expect a new interpretation of Article 1, a new Oakes test, or a reversal of the Oakes test in the coming years? The political landscape is changing. The world is changing. Is it something that can endure time?
There are really only two ways to go. And one is if you're going to have a justiciable constitutional rights document, one is to say, three ways to go. One is to say the rights are absolute, and no constitutional system does that. There always has to be some kind of backstop, some way of saying, in this case, the collective interests outweigh the rights. Two is to just say, judges should just decide these policy issues in a sort of open way. They should just say, I like this interest and think it's more important than that interest. And three is to try to run them through a gauntlet, in effect, of logical, reasonable, rational, principled reasoning, almost to create a psychological disposition on their part to be objective as much as that's possible. And I think that's what Oakes does. And as Marcus points out, and as I was saying before, Oakes incorporates both the kind of measurement and this more open balancing. So it does transcend any kind of particular politics in a substantive way. It's a process for making decisions that have to be made if you have constitutional rights. Now, the degree to which we have constitutional rights, I think, is a real issue, with governments increasingly moving in a kind of populist right-wing direction, and those governments becoming much more inclined to invoke Section 33. One can imagine a future where the Charter becomes a less significant protector of rights as governments become more prone to excusing themselves from the obligations of rights. And in that regard, I think there's another point I want to make about Oakes, which I don't think is made enough. I mean, on the one hand, it is significant that it creates this test for determining whether legislation should live or die when it restricts a right. But the other thing that Oakes does, which is very much related to this turn to right-wing populism, is it defines democracy. It creates an authoritative constitutional definition of what democracy is in Canada. Chief Justice Dickson defines what a free and democratic society is. as respect for the inherent dignity of the human person, commitment to social justice and equality, accommodation of a wide variety of beliefs, respect for cultural and group identity, faith in social and political institutions that enhance participation of individuals and groups in society. That's a very different understanding of democracy than you might get in a lot of other places, including the United States, current and past. It talks about collective values. It talks about social justice and equality. It talks about pluralism. We have in Canada a definition of democracy that is constitutionally entrenched. We need to think about that when we're thinking about Section 33 or various other elements of emerging and increasingly populist right-wing kinds of illiberal kinds of governments.
Section 33, obviously the notwithstanding clause, which is important, which is also unique amongst constitutional democracies, liberal democracies. Professor Moore, do you think that the Oakes test shaped the interpretation of the rest of the Charter over the decades?
I think it's had an effect in particular in that if you consider the alternative, right, that I mentioned in the United States where they develop internal limitations for each right. And so if you're using the approach that we have instead with Section 1 and an Oakes test that is a single universal limiting principle for all the rights, then the sort of prima facie content of the rights is going to be quite broad. You're going to rely on Section 1 to assess whether there's a limitation. And so, for example, our definition of freedom of expression is very broad, like almost everything is going to qualify as freedom of expression. The real question is going to come down to Section 1 in the Oakes test to decide whether it's the kind of expression that is going to be protected by the Constitution, by the Charter. You could imagine things being different if you didn't have that Section 1 that freedom of expression itself would maybe have to be defined more narrowly and more carefully with respect to different contexts and different kinds of speech and stuff.
Marcus is right about a right like Section 2B, freedom of expression communication. It's very, very broad. And so Section 1 does a lot of work. But when you take a right like Section 7 or Section 15, those sections have internal limitations. So Section 7 says you have these rights, but it's okay for the government to take them away so long as that's consistent with principles of fundamental justice. And Section 15 says you have these rights, but it's okay for the government to take them away so long as it's not acting in a discriminatory fashion. So they each have built-in limitations, which is why most cases under Section 7 and Section 15 don't end up going to Section 1, because a lot of the kinds of reasoning that you get in Section 1 is used within the internal limitations. So the Section 1 jurisprudence looks very different depending on the right that you're dealing with. And then Section 2D, freedom of association, is very interesting, even though it's stated in very broad terms like freedom of expression. The court saw fit, in early jurisprudence at least, to build internal limitations into it, in much the same way Marcus was describing as happens in the United States. So there is a lot of inconsistency when you look at the relationship between any given right and Section 1. Each right is going to relate to it somewhat differently, depending on the nature of the right and its expression.
With the bench that we know today, do you think that they would have rendered a similar decision on Oakes and the interpretation of Section 1?
Absolutely. I think, though, they would have done it under the second stage, under the minimal impairment stage. In terms of how the jurisprudence has evolved, the rational connection test has become a very, very low barrier to get over, and most of the work is done at minimal impairment.
Should we be proud of that decision?
Absolutely. I've seen public opinion surveys that have identified the Charter as one of the things that Canadians are proud of and associate with their national identity. And the Oakes test is a big part of how the Charter works in practice. how it's operationalized into the lives of Canadians. It has stood the test of time. It's surpassed the test of geographic boundaries and spreading, to other jurisdictions around the world. It's definitely a landmark case. It's definitely a case that will have an enduring legacy. That said, we don't want to get carried away too far and become rigid that we can't refine the test in any way, that it's perfect, that there's no refinements that could be made. And I think we've alluded a few times throughout our discussion to the minimal impairment step of the test being the one that does much of the work, and the fact that initially in Oakes, we had a very strict expression of it. The government's action has to impair the right as little as possible. If you take that literally, it's a really extreme constraint on what the government can do. And that's why you saw very quickly in Edwards' books in the same year as Oakes, a relaxation, a pretty significant relaxation, very different language used there, perhaps even more relaxed than the reasonable limit language in Section 1 itself. And we've seen that, an inconsistency that has continued all that time since, where if it helps reach a particular conclusion to use the stricter version, then we see that one used maybe. Whereas, if it helps fit the conclusion that to use the relaxed version, and we see that one used. And so that's a problem, right? When we have different versions, a strict version and a relaxed version. And there have been attempts to sort of rationalize or develop principles about when each would be used, but that hasn't happened. It hasn't followed that pattern. That's something that needs to be corrected. It's a refinement. It's not throwing out the test or anything, but it's important to fulfill the promise of the Oakes test in being able to rationalize and discipline the justification process for limiting rights. And so I think if we stick more closely to the text of Section 1 there and stating a standard of a reasonable limit, then we could have more consistency in the adjudication of human rights limitations. And I think that would increase confidence in the courts. And I think that would, in fact, enhance the protection of human rights because it would be a single standard rather than the uncertainty of which standard will be used. That's one thing I think that there's still some refinement that could be made to improve.
Professor Bakan, when the judgment was rendered, did you know at the time that it was going to be so impactful? Was there a feeling in the courts?
When Chief Justice Dickson was working on the Oakes draft and writing what his biographers Kent Roach and Robert Sharp described as 5 of the most important pages ever written in Canadian constitutional law, I think the Chief Justice had a sense that he was writing 5 of the most important pages ever written in Canadian constitutional law. I think if he were here with us today, he would be proud of the legacy of Oakes, but he wouldn't be surprised by it. And I think, getting back to Marcus's point about the different standards that are often deployed by courts using Oakes, one of the things that the court has tried to do, and I think Edwards' books is a very good example of this, is to, reflect what the Chief Justice defined Canadian democracy as being: respect in institutions, social justice, social equality, and to adopt a less rigorous approach to legislation that is aimed at protecting vulnerable groups, to, in effect, respect the social democratic project of using legislation to try to promote social equality. When we're dealing with vulnerable groups, like workers in the context of their corporate employers, and we're dealing with legislation that is aimed at protecting them, we need to be more deferential because of that value that is inherent in our particular approach to democracy.
Professor Moore, thank you so much for taking part of Shaping Canada, 150 years of landmark decisions.
Thank you.
Professor Bakan, thank you very much for taking part, and thank you for your time.
Yeah, thank you, Hugo. It's been a real pleasure talking with you and Marcus.
Thank you for joining us for this episode of Shaping Canada, 150 years of landmark decisions. As we've explored today, the law is not static, it is living. Every Supreme Court ruling adds another stone to the foundation of our society. For links to the decisions discussed and more information about our guests, visit shaping-canada.ca and make sure to read the show notes. Subscribe on your favorite podcatcher so you don't miss any part of the series marking the 150th anniversary of the Supreme Court of Canada. Thank you to everyone who contributed to this project: the Supreme Court of Canada, the Right Honourable Richard Wagner, Chief Justice of Canada, the Honourables Nicolas Kazirer, Suzanne Côté, Andromache Karakatsanis, Sheila Martin, Malcolm Rowe, Mahmoud Jamal, Michel Obonzawin, and Mary Moreau, Professors Louise Langevin, Jocelyn Downey, Carrie Frock, Naomi Metallic, Karen Drake, Denis Nadeau, Félix Mathieu, Éric Labelle-Eastaff, Marcus Moore, Joel Bakan, Howie Kislowitz, Richard Moon, and François Tanguay-Renaud. Thank you to Maître Michel Lebrun, Miss Sandrine Raymond, Laurence Laperrière, and Laurence Thériault, Mr. Peter Warren, and our producer, Constance Saint-Pierre. This project has been made possible by the Government of Canada. I am Hugo Martin. Until next time.